Chapter 11.
That's pretty nice. Got a good hefty weight.
My name is Jessie Hill. I'm an assistant professor here at the law school and assistant director of the Institute for Global Security Law and Policy here at CASE. It's my pleasure to introduce the next panel, which is on the subject actually alluded to by Professor Sussman at the end of the last panel, outsourcing torture and extraordinary rendition. Our first speaker, panelist, will be Michael Newton, who is a professor at Vanderbilt University Law School and formerly lieutenant colonel and associate professor at the U.S. Military Academy. Professor Newton is a highly sought-after speaker on issues of accountability and conduct of hostilities. He has taught Iraqi jurists, and he's active in the effort to establish the Iraqi Special Tribunal. He was the U.S. representative on the UN planning mission for the Sierra Leone Special Court, and he has also served as special advisor in the Office of War Crimes issues. He will be giving a talk today entitled War by Proxy, Legal and Moral Duties of Other Actors Derived from Government Affiliation. Our second panelist is Professor Laura Dickinson. Professor Dickinson is an associate professor at the University of Connecticut School of Law. She's a graduate of Harvard College and Yale Law School, and formerly served as policy advisor to Harold Koh, who was the Assistant Secretary of State for Democracy, Human Rights, and Labor at the U.S. Department of State. She has served as a law clerk to both Justices Harry Blackmun and Stephen Breyer on the U.S. Supreme Court and Judge Dorothy Nelson on the U.S. Court of Appeals for the Ninth Circuit. And she's published extensively on accountability of government and private actors under international law. Finally, our third panelist will be Bob Strassfeld, who is a professor here at CASE at the law school. He teaches torts, federal courts, labor law, and legal history. He has published articles on the theoretical aspects of causation in the George Washington and Fordham Law Reviews, and on law in the Vietnam War in the Wisconsin, North Carolina, and Duke Law Reviews. He's also co-author of a case book on labor law. His current research includes work on the legal history of the Vietnam War, and he's going to be speaking about American innocence. So I'll introduce my first panelist, Professor Michael Newton.
Thank you. Can you see me in the back? I thought I might need to stand on a chair or something. You just kind of give you this sense. Well, thank you. It's a pleasure to be here. I'm happy to talk offline with some people. In my career, I've done an enormous amount of training in law, war, and substantive humanitarian law issues. If you want to know how it works, how we really train, you can question what training do they have? What are they supposed to have? How does it work in practice? I'd be happy to talk about some of that offline. I want to try to do something maybe a little bit unusual for this forum. But as we are in a law school, I want to try to set out the substantive framework of the laws themselves. My thesis being that you would think, with the very broad treaty obligation that we have, for those who haven't looked it up lately, I will read it to you. Well, my paper's got messed up. The Torture Convention obligation in Article 2 gives us a very, very broad obligation to implement, very broadly, legislative, judicial, administrative remedies in every territory under our jurisdiction to address the problem of torture. Now, it's a very broad treaty-based responsibility, which under Article 6 is the supreme law of the land. That is not debatable by anybody here. The question is, how are we going about implementing that? And my thesis, in short, is when it comes to civilian contractors, it is a mess. You all realize, of course, that outsourcing is a contractual term. That's what we do. We outsource our yard work. We outsource our automobile care. Outsourcing simply means that we have another actor that we've hired to undergo in a particular task. And when we say outsourcing in many contexts, as was done earlier this morning, we're talking about the problem of outsourcing to other nationalities, other actors beyond the United States. I want to focus at home first. You know, to quote Jesus Christ from Luke chapter 4, "Physician, heal thyself." You know, the problem starts with us. The problem starts with our own practices, with all the territory under our jurisdiction, and in particular, as I understand the law, it is not a tightly woven, interconnected piece of statutory framework that gives us a clearly settled basis for regulating the conduct of private actors under United States quasi-authority in the world today. And this is true in Afghanistan, it's true in Colombia. This is a real problem. And I know a little bit unusual for a law school, but I want to talk about the law. I want to focus on the substance of the provisions that are out there today. Now, in a sense, we've all seen the public commentary, this is a new kind of war. And that's true in a political sense. In the context of dealing with contractors, though, we're also in a very new era. The second largest deployment of forces in Afghanistan and Iraq today is, of course, the United States has the largest concentration of forces in both those areas. The second largest is private contractors. Tens of billions of dollars being thrown around, your taxpayer dollars, to hire contractors to do things that in the good old days, when the Army was 40% larger, were done by uniformed military personnel, which goes to the question earlier, what kind of training do they have? In the old days, we could say, here is a set amount of doctrine, here's a set training base. The United States Army led the world in the development of professional military education. That's a fact. Armies, militaries all around the world copied our training bases because it was the way of instilling professionalism and discipline and therefore ensuring that proper standards were followed. You lose all of that the second you take a wad of money and you pay somebody from Blackwater or Executive Outcomes or California Microwave or Kellogg Brown and Root to do the same kinds of things. There's a fundamental principle of military doctrine that is also lost, and it's called the principle of objective. And we sort of recognize this as common sense, but let me give you the doctrine. The principle of objective is one of the very 8 fundamental principles of war. What it means is simply this, that every effort has to be focused on a common objective. Otherwise, it's counterproductive and shouldn't be pursued. In military terms, we call that the mission statement. What's the focus? What's the objective? Now, the problem with that is that when private contractors enter an area of operations under the command of a United States combatant commander, they enter that theater and they are paid their money precisely because somebody at the higher levels of chain of command have made a policy determination and a military determination that their presence in that theater, what they've been hired to do, advances the overall military mission pursuant to the principle of objective. But as soon as they enter that theater, they become free agents, free actors. And this is a great problem because you now have a cultural disconnect, which those of you who've been in Afghanistan, those of you who have talked to military officers on the ground will, I think, readily acknowledge. I was talking to Sharif about this earlier. There's a big disconnect between professional military officers who have a sense of mission and a sense of dedication and a sense of honor and a sense of professionalism, who have private contractors in and around the areas of their troops. Sometimes they look like troops. Sometimes they wear bits and pieces of uniforms. Many times they're armed because private contractors in those areas, of course, have the lawful right of self-defense. That's their fundamental human right, so of course they're armed. The problem is they're not combatants. They're not within the military chain of command. And when a commander tells a contractor to do something, they may or may not do it. They will only do it if it's convenient to them. They will only do it if they feel like doing it. They're not within... Now, sometimes we can complain, as I have through the years, through the course of my military career, about a hierarchical, rigid structure of military discipline, but sometimes that's a good thing. When we're dealing with the problem of torture, cruel, inhumane, and degrading treatment, it's a very good thing to have a commander specifically charged with the moral and legal duty of preventing those things under his command. The problem is when we have private contractors in that area, they are not within that hierarchical structure. And there are big problems accompanying that. Now, this is a particularly opportune time to talk about these kinds of issues for 2 reasons. One is, I don't know if you saw the news. Some of you are in law school, so I know you don't watch the news very much. But just last week, we had an American contractor in Iraq who was rescued by military forces. That's a good thing. But it also illustrates the moral dilemma here. These are people who are pursuant to quasi-U.S. government policy, being paid with U.S. government dollars, not under U.S. government command, yet ones over whom they're still American citizens, many of them. Many of them are retired military. So there's a very strong moral obligation to help these people when they get into trouble. And yet, a priori, they're still operating sort of a parallel channel of operations and commands, and it's a very difficult operational problem. The second reason why this is particularly appropriate now is that finally, at least on paper, federal policy is beginning to catch up with events on the ground. Okay? I hold in my hand, and I can email this to you if you want, statutory training requirements for contract personnel who interact with individuals detained by the Department of Defense on behalf of the United States government. Now, this is the Deputy Undersecretary of Defense for Acquisition, Technology, and Logistics. Formal policy memorandum directed to all combatant commanders and, importantly, all contracting officers. Remember that every contractor out there is deployed pursuant to a contract that's been made in accordance with U.S. contracting rules. That's why this comes from the Director of Logistics and Acquisition, because all those contracting officers work for this Deputy Undersecretary of Defense. The date of this is 12 September 2005. Now, you'll be shocked. Let me tell you what it says. And this is pursuant to, this is actually the follow-up to a snippet that was in the fiscal year 2005 Department of Defense Authorization Act. So last year's DoD Authorization Act. Congress said, we are not satisfied with what's going on in terms of the oversight of contractors. Too many free agents out there operating outside the military chain of command. Come up with a policy to fix that. Well, here it is, pursuant to the statutory mandate. Here's what it requires as of now. And this has been implemented in DFARS, and I don't use the acronym. It's the Defense, Federal, Acquisition, Regs, and Supplements. So they've now promulgated an interim rule. The Reader's Digest, the layman's version of this is, if you want to get a contract, you have to do it in accordance with DFARS rules, U.S. contracting rules. So an interim rule has been promulgated pursuant to the statutory authority in FY 2005, and now it's been implemented in this hierarchical military structure, telling all contracting officers, implement the law. Now that's a good thing, sort of. Let me tell you what it says. Let me tell you what it says. It says, if you're going to deploy on behalf of a United States contract, and realize now, we're, just to put some bones on this, we're talking about not just people that are being logisticians and people that are you can't swing a stick in Iraq today without hitting a contractor. I promise you. I promise you. People that are feeding us, people that are transporting our water, people that are doing customs regulations, anything you can think of that doesn't have to do with actual war fighting, we've got contractors doing it, to include interrogations and support to that. So put that context here. What's the new policy require? And this is pursuant to Congress's statutory mandate. 1, receive training regarding the international obligations and laws of the United States applicable to detention of personnel. Oh, I'm very comforted by that. So they're going to get some training now. Well, great. Who's responsible for doing that? There is no amplification of that requirement whatsoever. None. It just says they have to be exposed. Yeah, there's some law out there about how we treat people in U.S. custody. That's it. 2, acknowledge receipt of the training. Well, okay, great. You know, how many of you law students? How many law students in here? How many of you can tell me what your school's computer use policy is in the library? I know you've been trained in that in the beginning of your law school experience, and you probably signed something that said, I acknowledge receipt of this training. What's the practical effect of that in your day-to-day operations? And I think you can largely put this in the same category. Remember, we're talking about billions of dollars in contracts. There is a huge economic financial incentive for contractors to check that block and then move on to the bank. And that's where we are today. Okay? Finally, and this one starts to hit home a little bit more for me because it's in more familiar terms. The combatant commander responsible for the area where a detention or interrogation facility will provide the training to contractor personnel already in the area. Now that's serious. And there's a policy directive here to those 4-star American generals to implement that. Now that means something because there's a hierarchical command structure there. Those 4 stars will do that to the best of their ability. My prediction is, and I'm talking out of school is that this will be very hit or miss and a very uneven quality because there's no subsequent follow-on standards for the proper implementation. There's simply a broad statement to train them in what their rights are. So that's where we are today. Which ought to raise the question, at some level, why is this necessary even? You know, this is not a new problem. And in a sense, the most successful counterinsurgencies that we fought in our history have been well-integrated civil-military operations. And I would point to the Philippines insurgency as a great example. Well-integrated civil-military operations done under military authority. People knew what they were doing, and it worked. Because the message was consistent, the focus was consistent, it was based on American values, and when people stepped out of line, they were prosecuted. Trivia question. When was the last time we prosecuted a brigadier general in the United States Army? Philippines. Philippine insurgency. Guess what the charges were? Mistreatment of civilian detainees in U.S. Army custody. Okay, there's a well-integrated civil-military plan, and it worked. The problem is that when you integrate this new element of civilian contractors operating outside the military chain of command, it's much, on an order of magnitude, much more difficult to conceive and implement this well-integrated civil-military strategy. Now, you might think, for those who do law and economics, you might think, well, okay, the economic incentives themselves will work to police this, to keep contractors up to standard. Because after all, if you don't play by the rules, if you're not doing the job, you could logically see the economic consequences. You won't get the next contract, right? Wrong. Bad assumption. DynCorp contractors in Bosnia were responsible for widespread abuses. I mean, videotaped rapes. Okay, just as one example. Widespread torture, widespread abuses. Guess who has the contract today for $250 million inside Iraq to do police training for the Iraqi police? DynCorp. It's a very small field, and the problem you run into is really one of both operational expertise and security clearances. I mean, it's a very small universe of companies and individuals who are prepared to go into these places of the world, even if you're offering them billions of dollars, and actually do the kinds of things that we have to contract for. So it's a small field. The economic incentives really don't work, precisely because of those things. So, they're not combatants. The other reason why this is particularly appropriate, and I would refer you to the Federal Register, and I can give it to you if you want to email me, but in May of this year, May of 2005, the final federal rules for the treatment of contractors procured on behalf of the Department of Defense were promulgated in the Federal Register. And they're intended to be the all-inclusive, sweeping statement of rules. I will tell you they are not. There are still many holes in them. So, what are we left with at the end of the day? There's no economic incentives that are going to really check their behavior. The command structure is not able to completely check their behavior. The contracting rules themselves really aren't going to check their behavior. So what are you left with? You're left with statutory enforcement. Remember, our obligation under Article 2 of the Torture Convention is provide effective administrative judicial penalties for people who torture in any place under our jurisdiction. Now let me lay out the law for you very quickly and show you why that's still an inadequate solution. First thing, we have a rule in military practice called the Military Extraterritorial Jurisdiction Act, MEJA. It was passed in 2000, and it was designed to be this all-inclusive, we're going to pick up all those contractors out there. Here's why MEJA doesn't work. Let me read it to you. Whoever engages in conduct outside the United States, that would constitute an offense punishable by imprisonment for more than 1 year if the conduct had been engaged with inside the special maritime and territorial jurisdiction of the United States, et cetera, et cetera, et cetera. Great. We've got a worldwide sweeping ban. One of the provisions in the Patriot Act, however, extended the special maritime and territorial jurisdiction of the United States not only to the normal places we think of, but also to every area where we have diplomatic facilities and military coverage. So Bagram Air Base is today within the special maritime and territorial jurisdiction of the United States, which means that MEJA, designed to create and apply to DoD contractors all around the world is completely meaningless when it comes to the enforcement of their conduct. MEJA's not going to work. Okay, great. What about the Torture Convention Implementation Statute, 18 U.S.C. Section 2348? Look it up. It's, same thing. Torture Convention Implementation Statute applies outside the United States. So when we expanded the Special Maritime and Territorial Jurisdiction, we effectively said the punitive remedy that we put on the books to deal with torture is now not relevant to the policing of this conduct. That's a problem. What about the Uniform Code of Military Justice? Great fix, right? Because you've got U.S. combatant commanders all over the place who have worldwide in personam jurisdiction and worldwide subject matter jurisdiction over war crimes and certainly assaults and torture and all the kinds of things we're talking about. Are they within civilian contractors? Are they within the Uniform Code of Military Justice? After all, the UCMJ says in Article 2 that in time of war, persons accompanying the force are subject to jurisdiction. Here's the problem with that, of course. In time of war is defined statutorily and legally in all of our case laws being a declared war by Congress, which we're not in. Also, that broad phrase accompanying the force has been interpreted in judicial findings to exclude contractors. Just the way it is. They are not accompanying the force for the purposes of that. So what are we left with? We're left with, and the only thing we're left with now is exactly what's going on in the case of the CIA contractor in the Eastern District of North Carolina, if I said that right, Raleigh, in the Pissarro case. CIA contractor from Afghanistan. The only thing we're left with, since we've now extended special maritime and territorial jurisdiction in every place around the world where U.S. forces are present, we're going to charge him under the normal federal criminal code with the crime of assault. Okay, great. That means that you're now exporting all the federal rules of evidence, all the federal rules of criminal procedure, all the right mechanisms for investigating. And if you've ever been in a deployment environment and tried to bring in FBI agents to conduct a full-blown FBI investigation under our normal rules of federal criminal procedure, just like it's in Montana or Ohio, you know how hard that is. So what we're left with at the end of the day is a statutory structure which, in my view, is inadequate to deal with the current problems that we face. And the lines are going like this. Remember, the problem is getting bigger as we deploy more and more and more contractors to do more and more things, and we pay them more and more money, and we put more and more pressure on them to earn that money. Bring us the information, right? Earn your money. The problem is getting greater, while our statutory ability to deal with that is decreasing, in my view, almost to the vanishing point. That is both a legal and a moral and an ethical problem that puts the United States squarely in the position of having a treaty obligation to deal with these things and a gaping hole in our ability to meet that treaty obligation. Thank you.
Well, thank you so much to Michael Scharf and to Jessie Hill for inviting me to participate in this conference. And it's great to follow Mike Newton's comments here. The perhaps radical thesis of my remarks today is that military outsourcing to private contractors, as much as it presents a risk, a serious risk of abuse, such as torture, may also present an often overlooked opportunity for providing accountability for such abuse. And that is that the contract that is the engine of privatization may, in some cases, may be a tool of accountability, and one that may even be more effective than the typical existing international law approach. Now, as Mike has laid out, it's become very clear that in recent years, we've seen much more outsourcing of what we might call foreign affairs functions of government. And this extends across the board, but most notably for our purposes today in the area of military affairs. In the first Gulf War, the ratio of uniformed personnel to contractors was 1 in 100. In the current war in Iraq, it's 1 in 10. And our military is outsourcing everything from logistical functions to tactical planning, as well as interrogation. In fact, at Abu Ghraib prison, the torture was committed not only by uniformed personnel, but by private contractors working for a company called Khaki, who reportedly were directing the activities of the uniformed personnel. Other countries, such as Sierra Leone, have used private military contractors to engage in direct combat, and the United Nations has had a serious debate about whether to use private contractors for peacekeeping purposes. Now, the rise of non-state actors in international law raises serious concerns about accountability, in part because many international law norms are framed primarily as obligations on state actors. And this is true with respect to the norm against torture, which is primarily framed as a prohibition on official misconduct. And as more and more international, in the international arena, as more and more non-state actors emerge on the scene, there's a question about whether they're going to fall through the cracks of international law. And Mike has outlined some of those cracks for us today. But the response of international law scholars has, to my mind, been inadequate here. In fact, as I began to research this project, I was surprised to find that many scholars haven't really focused on privatization in this sense. That is, the outsourcing through government contract of all of these different functions. Now, of course, international law scholars have entered into a very rich debate about the rise of non-state actors generally. But non-state actors are, of course, very different from one another. A guerrilla soldier is very, very different from a private contractor. And to the extent that scholars have and practitioners have focused on this problem, I think that their proposals have fallen short. One approach is simply to oppose privatization altogether. I think this is misguided because, at least in the near term, I think privatization is irreversible. And so I think that if we focus on trying to stop it, we're going to lose sight of opportunities to contain it or to contain the abuses. Others have argued that we should expand the normative framework. We should revise our treaties and interpret customary international law expansively to bind non-state actors directly, or we should interpret the existing state action requirements to the extent that they exist very broadly, so that private actors are brought within their ambit. I think this is very important, obviously, because it can expand the normative framework of international law. But the response has also been very court-centered and tribunal-centered. And again, while this is an important strategy, even if enough courts and tribunals were established, fully functioning and fully effective to handle this, it would be they wouldn't be able to try very many cases or handle very many cases. So I think we need to look to alternative approaches to this problem as well. And as I cast about looking for such alternative mechanisms, I was drawn to literature in domestic administrative law in the United States, where scholars have really been grappling with the problem of privatization for a couple of decades, as the U.S. government has increasingly farmed out a variety of functions, from health care to education to welfare to, of course, prison management to private contractors. And these scholars have really worried a great deal about whether this is going to erode public law values in the United States. And some have argued, again, flat out against privatization, but others have really sought to find a middle ground and have suggested that privatization might offer an opportunity to extend public law values into the private sphere through the government contracts themselves. And so given that a hardline anti-privatization argument seems fruitless in the international sphere, I started thinking about whether we could bring more pressure to bear on these contracts and promote public law values, and in particular the public law value of human dignity that encompasses the norm against torture. And in fact, I think a contractual approach in the international sphere may even be more fruitful than in the domestic context because the available legal sanctions with regard to governmental actors is already comparatively weaker. So one can understand in the U.S. context that critics might argue that we're going to lose a great deal when we privatize. In the international realm, while the baseline isn't as high, I don't think this is a cause for celebration, but it does mean that we risk losing comparatively less. So that's how I got interested in thinking about how we could import public regarding norms into military contracts. So what I'd like to do in my remaining time is to lay out 8 possible steps that we could take to increase accountability through the use of these contracts. But before I go into these reforms, I just want to address 2 objections that I think many of you may have in the back of your minds. The first one is that, well, isn't the reason why governments are privatizing precisely to avoid accountability, right? That's what the remarks from earlier today would certainly suggest. And, you know, that may well be true. But I think it's important to remember that governments are not monolithic. There are plenty of people in bureaucracies who may want to affect change. NGOs, international organizations, and other constituencies can have an effect on the government. And there may be things that these organizations can do that is even independent of what the government does. And second, a second objection is that, and Mike alluded to this, that all of this is going to cost a lot of money, and what matters to contractors is the bottom line. So you'll either just drive away contractors from the government altogether, or that the cost will be so high that you'll eliminate any efficiency gains that you might have reaped from privatization to begin with. So essentially, you'll eliminate any of the benefits of privatization. Now, as to this objection, I think we've got to do a lot more empirical work to see whether that's actually the case. First of all, it may be that these private contractors aren't going to run away from government contracts, because it's not as if there are a lot of other consumers that are going to hire them. And in fact, I was just talking to a contracts expert at GW who said there's actually only one case of a government contractor actually deciding not to contract with the government, but they enter into subcontracts. So, and in any event, I don't think it's so clear that the costs will necessarily outweigh the benefits. It, of course, depends on how you measure the costs. Okay. So now turning to these 8 possible ways in which the contracting process could try to incorporate public law values and the norm of human dignity. Number 1, the contracts themselves could explicitly incorporate the norms of international human rights and humanitarian law and bind the contractors explicitly. Now, this may seem like an obvious point, but none of the publicly available Iraq contracts does this. It would be a good starting point. And in the domestic context, we see this regularly in contracts between states and operators of private prisons. The contracts regularly include provisions that say that the contractors are held to the same standards that state employees would be under constitutional and statutory law. Number 2, foreign affairs contracts, military contracts, could explicitly require that the contractors get training in activities that would prevent abuses like torture. Now, the DFARS amendments have gone a step in this direction, but they obviously need to go much further, as Mike was saying. And, in the domestic setting, again, these provisions are utterly commonplace. It is a standard term in the contracts with private prison operators that the employees are going to get the same training that state employees would get. The contractors get the same training that state employees would get. And so you could beef up the training requirements, which are in the Iraq contracts virtually non-existent. In fact, it's not surprising that an Army Inspector General report on the conditions that led to Abu Ghraib concluded that 35% of CACI's Iraqi interrogators did not even have any formal training in military interrogation policies and techniques, let alone training in international law norms. Number 3, provisions could be made for increased contract monitoring. Such monitoring should include, to begin with, sufficient numbers of trained and experienced governmental contract monitors, supplemented by ombudspersons who are leaders of independent offices charged with monitoring abuse, and supplemented by outside oversight by independent organizations. Now, in the domestic context, this framework is, again, this 3-tiered framework is commonplace. With respect to the military contracts, though, you have some of it on paper. In practice, it's pretty ineffective, in part because the contract monitors themselves don't have any training in international law norms, so they don't know what to look for. The ombudspersons have been somewhat better, but they're mostly focusing on the norm of anti-corruption and not on human rights abuses. So I think that this form of monitoring could be dramatically increased, as well as opening the door for outside monitors to come in, like the ICRC, to look at what private contractors are doing as well as governmental actors. Number 4, accreditation. Independent organizations, often consisting of experts and professionals in the field, can evaluate and rate private contractors. Again, the domestic context provides fertile ground for examples here. In the healthcare setting, there are numerous examples of this. There's an organization called the National Committee on Quality Assurance, NCQA, which is an independent organization that rates HMOs that are getting public funds. And it started out as an independent effort, but states now routinely require NCQA certification as a condition for getting a contract. In the private prison area, private companies often have to get ACA accreditation, American Correctional Association accreditation, before being awarded a contract from a state. In the international area, the military contracts are notably devoid of any such accreditation requirements, despite some nascent efforts to accredit various corporations generally for human rights and labor standards and environmental standards. There really hasn't been an effort to use this accreditation process in the contracts. And also, on the part of private organizations, there really hasn't been as much of an effort to rate these military contractors in a way that could be used in these private organizations, although there has been some. Number 5, the contracts could incorporate specific performance benchmarks, specifically geared toward compliance with international human rights and humanitarian law norms. So, it could be a requirement of the contract that you have a zero tolerance policy on abuse. If there are instances of abuse that the contractor has agreed to deal with it internally with an internal sanctioning mechanism, these kinds of performance benchmarks, again, are used routinely in domestic privatization examples. We don't see use of this yet in the military contracting area. Number 6, mandatory self-evaluation. This may seem like a wishy-washy thing, but it is used regularly in the domestic context, and it aids in monitoring. If you require a contractor to perform rigorous evaluation of its own practices, it can be a benchmark for outside monitors to come in and assess compliance with norms, and it requires the organization to begin to think institutionally in its culture about those norms and what policies it would have in place to prevent abuses. Number 7, the contracts could include terms allowing the relevant government to take over the contract by degrees and ultimately terminate the contract, graduated penalties. Now, under the Federal Acquisition Regulation and the various statutes that apply to contracting, the government can terminate these contracts, but rarely does. The khaki case is a case in point when the employees of khaki were determined to be implicated in the abuse at Abu Ghraib. The khaki contract wasn't terminated. It was actually expanded. And although the employees were ultimately fired. And, part of this is because termination is a very blunt instrument that governments are reluctant to use. I think government should be encouraged to use the termination stick. But if you have other lesser penalties, such as graduated government takeover of failing contracts, that can serve as an added compliance mechanism as well. Finally, the contracts could provide for enhanced enforcement mechanisms. So they could, for example, give people who are affected by these contracts the opportunity for privatized administrative-like hearings. You could also include better third-party suit beneficiary provisions, and you could also expand whistleblower protections. Now, in the domestic context, we regularly see these privatized administrative hearings where a private contractor who's giving, who has a healthcare contract or a prison contract has to provide some kind of dispute resolution mechanism for people who feel they've been wronged under the contract. And those decisions aren't always subject to judicial review because they're not always considered to be, state processes. But nonetheless, they do give some measure of due process. So I think that governments could experiment much more with this in requiring private military contractors to have some kind of dispute resolution. Now, as I said at the outset, governments may be hesitant to adopt these kinds of reforms. But I don't think that objection makes this approach unrealistic. Some of these reforms may not initially have the power of the state behind them, but NGOs and international organizations and other constituencies can lobby the government to try to make such changes. And as the example of NCQA makes clear, private entities, accrediting bodies, for example, can have an impact even acting on their own. So if there were a push to do more accreditation, more ranking of these private contractors, it could have a very powerful effect even without the government's blessing. And it also can allow for a kind of transparency and public debate that can be very important. So in the end, whatever the drawbacks of the contractual approach, they are certainly no greater than the weaknesses of the current formal international law, transnational law framework that is fairly litigation-centered. And the use of contractual provisions may indeed open up other avenues of litigation by resolving some of the normative ambiguities inherent in the law. So international law scholars, activists, And advocates, I think, should spend at least as much time studying and lobbying for alternative mechanisms like contractual accountability as they do seeking further openings for litigation. Thank you.
I don't want this to be a reflection on all of my predecessors, so this is something that I won't have time to say at the end of my talk, because I'm sure I'll be told to stop before I've gotten to the end. So as we approach the lunch break, thank you for your endurance. One of my earliest enduring memories of the Vietnam War is of torture. Thankfully, this isn't a first-hand memory. This is from a photo essay published in Life magazine in June 1964. Nevertheless, the pictures and text produced memories that are vivid, powerful, and lasting. Under what would actually prove to be an overly optimistic title, A Little War, Far Away, and Very Ugly, the text and photographs presented a grim picture. Japanese photojournalist Akihiko Okamura was unflinching in his depiction of the misery and death that he saw. A portion of the essay involved a combat mission of a South Vietnamese, Army of the Republic of Vietnam, or ARVN from here on out, military unit near the Cambodian border. After a helicopter bombardment of the village, the ARVN soldiers were airlifted to the village where they met no resistance. Initially finding only women, children, and old men, they eventually flushed out 43 military-aged men who they assumed to be guerrillas. Despite Okamura's protests, hours of interrogation followed. The text and photographs depict ARVN soldiers beating and kicking the guerrillas. They placed the prisoners in uncomfortable stress positions, jackknifed into positions of agony, the author tells us. The ARVN soldiers also employed various water torture techniques. They held prisoners underwater in the nearby river, or put rags on the prisoners' faces, and then poured water on the rags to create the sensation of drowning. Elsewhere, Okamura published an account of his time in Vietnam, and he describes the torture in far greater detail than Life magazine did. The account is, as one would expect, chilling and disturbing. Without the benefit of recent Defense Department memos, the wisdom of the White House Counsel's Office, or CIA Director Porter Goss's assurances that such techniques are merely professional or rough interrogation, Okamura unhesitatingly called these acts torture. This last photograph actually wasn't published in Life. It perhaps was too grim for Life. It was published in a separate collection of Okamura's photographs. And unless people want to stare at torture photographs, we can turn off the projector and shut down. Up to you. Some people like torture photographs. As a 10-year-old waiting in my pediatrician's office for an allergy shot to help me cope with asthma, I focused especially on the water torture. I understood the panic that comes with the struggle to catch an adequate breath. Upon recently returning to the photographs, I find myself wondering about two questions that escaped my attention at the time. First, why was there no strong reaction to these photographs? There is hardly a mention in the letters to the editor of Life magazine in the weeks that followed. And second, and more important, and I think not unrelated, where are the Americans? Elsewhere in the essay, Okamura shows us and tells us about an American advisor to ARVN forces, and we know that many ARVN units at the time were accompanied by American advisors. Did an American advisor accompany the ARVN troops on this mission? If so, where was he when the torture began? Did he, as happened in so many veteran accounts from the war, go off to have a cigarette at the ARVN commander's suggestion? Given that this was hours of torture, that must have been a lot of cigarettes. We also know that the ARVN forces were transported to and from the village by helicopter. At the time, while there were ARVN helicopter units in Vietnam, the likelihood that ARVN pilots rather than U.S. pilots were involved in the mission are remote at best. Did American helicopter pilots land from time to time during the interrogation to resupply the ARVN troops? Did an American observation helicopter take in the scene from above, as another American helicopter crew did during the My Lai massacre? They incidentally landed and tried to stop the massacre and actually did rescue some people. We do know from a book that Okamura published about his experiences in Vietnam that 43 prisoners were transported on American helicopters to a military area in the rear. What did the American helicopter crews make of their beaten and damaged passengers, who incidentally, Okamura also tells us, gave up no information, either because they were incredibly disciplined or because they had no information to give. They did from time to time suggest places where weapons could be found, but there were in fact no weapons. And that didn't stop the beating and the torture. So what did the American helicopter crews make of these passengers and of the reception that they met when deposited in the rear, doubtless for a continuation of their interrogation? Were they shocked by what they saw, or had they seen it all before? What, in other words, was the relationship between Americans in Vietnam and the practice of torture by ARVN forces? Was it awareness, accommodation, acquiescence, or encouragement? Did we see these acts as a beneficial evil? To what degree were we implicated in these acts? I don't know whether the young George W. Bush saw these photographs in Life magazine in 1964, let alone what questions he may have pondered if he did. It seems unlikely to me that if he did see the pictures, he would have troubled himself much with the question, where are the Americans? After all, in response to the publication of the Abu Ghraib photographs and accounts of prisoner abuse that went on there, he tried to reassure America and the world that this is not America. And indeed, to varying degrees, I suspect we all found ourselves thinking that, and would have been even more prone to think that way in 1964. I think it's useful to think about, incidentally, Michael took care of law, so I'm not going to talk about law. It is useful to think about, thank you.
You can pay me later.
It is useful to think about extraordinary rendition as part of a larger story about how Americans have seen their relationship to torture and to other wartime atrocity. That relationship in our self-perception has been complicated. Sometimes the ferocity of our rhetoric has been shocking, and here I would differ with Michael about his characterization of the Philippines, putting down the Philippines insurrection. It was indeed successful. It was also extraordinarily brutal. As Richard Slotkin, Richard Drinan, and John Hellman have so ably described, we have often been drawn on frontier myths, including myths of Western gunfighters, and this is in quotations, savage Indians, in understanding our confrontation with other parts of the world, especially when that confrontation is tinged with racial difference. At times, including, I believe, at times today, we have characterized the wars we fight as savage wars, fought against an enemy that we see as peculiarly barbaric and bent on extermination. As John Dower has shown in his study of American images of the Japanese and Japanese images of Americans during World War II, there is much projection and self-justification at work when we employ these demonizing myths. Confronted with a savage enemy in a non-traditional war, the red flag is often the phrase, a new kind of war. This is not the first time we have called something a new kind of war, and as Alberto Gonzalez invoked that, it's often then a permission to engage in a new kind of warfare, which is also not new on our own part. We look to the unconventional warrior, the frontier hero, or in his modern inception, special forces and the CIA, the person who we say knows how to fight like Indians. And I'll run out of time, so I don't want to give you a lot of the rhetoric of pro-war advocates during the Philippine insurrection, but I will give you this from the war correspondent of the Philadelphia Ledger. The present war is no bloodless, fake, opera bouffe engagement. Our men have been relentless, have killed to exterminate men, women, children, prisoners, and captives, active insurgents and suspected people, from lads of 10 and up, an idea prevailing that the Filipino was little better than a dog. Our soldiers pumped salt water into men to make them talk, have taken prisoner people who peacefully surrendered, and an hour later, without an atom of evidence to show that they were even insurrectos, stood them on a bridge and shot them down one by one to float down as an example to those who found their bullet-riddled corpses. It is not civilized warfare, but we are not dealing with civilized people. The only thing they know and fear is force, violence, and brutality, and we give it to them. And while he was careful to deny American atrocities in his public statements, Teddy Roosevelt privately endorsed the use of the water cure in the Philippines. Yet this cold-blooded notion of warfare is very much a product of the particular moment during the Philippines insurrection, is not generally how we think of ourselves. Though we hear strong echoes of that rhetoric from time to time, especially in our most bellicose moments, we have a very hard time seeing ourselves in the pictures from Abu Ghraib, or imagining ourselves as the perpetuators of torture, abuse, and other atrocity in the more hidden corners of the world that haven't been penetrated by digital cameras. The grinning face of Lindy England is not, we tell ourselves, the face of America. The flight from this unseemly side of American warfare is also not new. The predominant theme in our thinking about our place in the world has been one of American exceptionalism and American innocence. And I would argue, and I will argue, that outsourcing torture through extraordinary rendition and through other mechanisms as well is a means of trying to preserve this self-identity as exceptional and innocent. Americans have long seen the American experience as one of new beginnings and an escape from the superstitions, prejudices, and practices of Europe. We have described the United States as a new Eden or a new Israel, and ourselves in Adamic terms. The American in de Crèvecoeur's famous formulation was a new man. The American was neither of the effete metropolis nor of the frightening and uncivilized, in Puritan descriptions, satanic wilderness. Rather, he was a civilizing force in a new land, unblemished by the many faults of the old ones. Americans have cultivated this contrast with Europe. We are a land with no castles and no kings, In fleeing Europe, we left behind feudalism and aristocracy, priestcraft and religious wars, and with them we also rejected the Star Chamber, the rack, and the thumbscrew. So at least goes part of our national myth. At the center of this notion of a new American is a notion of American innocence. As I will suggest later, if I don't run out of time, this image has not always been a flattering one. Innocence can connote both blamelessness and naivete. From time to time, our assertions of innocence collide with revelations of not-so-innocent behavior. In such moments, we may struggle briefly with the contradictions, but typically we seek shelter in comforting assertions that what we've seen is an aberration of a few bad apples. In his response to the breaking news of prisoner abuse and torture at Abu Ghraib, President Bush both condemned the behavior, but was quick to assert that it was aberrational. We stand, after all, for freedom. Similarly, in the immediate aftermath of the revelations of the My Lai massacre, in the face of vivid photographs of dead civilians, there was widespread denial that the massacre occurred, or that if it had, it could possibly have been perpetuated by Americans. The author of a study on the American response to the news of My Lai captured this reaction in their title, "It Didn't Happen, and Besides, They Deserved It." Today, My Lai is forgotten by many and has never been heard of by many too young to have forgotten it. The sad fact, however, is that our relationship to torture and other atrocities is more complicated and less innocent than we or President Bush would like to believe. I want to examine that relationship and the ways in which we try to distance ourselves from torture and atrocity. And I think there are really two kinds of ways that we do that, one of which other people have and will ably discuss. So I will just note them, but not do anything more than that. Ways in which we try to hide instances of our own behavior through redefinitions or crab definitions of the word torture, delegation to off-the-books agents, whether they are private contractors or the CIA, relegating our prisoners to jurisdictional netherworlds as ghost detainees or to places where we assert that the Constitution and the courts don't reach, whether Guantanamo or the Oval Office. If I had more time, I would talk about sort of nod and wink techniques as well. There's a wonderful description by Donald Duncan, a disaffected Green Beret who left the service and became an anti-war vet and critic of militarism, about being taught torture techniques in a course on countermeasures to hostile interrogation, where everybody in the room understood that there were no effective countermeasures, and this was really being taught torture techniques. Having said that, it's also important to note that Green Beret doctrine favored psychological rather than physical techniques, and that the military has, because of the professionalism that Michael mentions, and because of a belief that this is both ineffective and also ultimately bad for us, has been the source of a lot of the protest. But what I want to turn to instead is the technique of othering the torturer. In Vietnam, there was a widespread practice of turning enemy prisoners over to ARVN interrogators or to the National Police. We did that knowing that the likely outcome would be torture and, in many instances, murder. Favorite interrogation techniques included the use of water torture, beating, and the application of electricity. The testimony of returning vets at the Winter Soldier hearings and at Congressman Conyers' hearings in 1971 attest to the widespread use of torture. While American interrogators described instances of American abuse, much of what they described was torture of Vietnamese by the Vietnamese. This story was widely told not only by anti-war vets, such as those who were testifying at those hearings, but noted for years through the press and by returning GIs. Duncan, for instance, describes Vietnamese prisoners being handed over to interrogators in one instance in which a frustrated interrogator disemboweled the prisoner. The assertion was commonly made by GIs that they declined to protest knowing that it would do no good and might threaten their careers, although finding examples of GIs whose careers were actually in some way impaired for reporting torture is hard to do. And as Malcolm Brown, who was actually fairly cavalier about torture in Vietnam so long as it didn't leave marks or was disfiguring, in his book, The New Face of War, reports there was widespread disbelief that the United States couldn't stop the practice of torture if it demanded it. This is only half the picture. The other half of the picture is political prisoners in Vietnam and the practice of torture with American acquiescence, knowledge, and often presence of political prisoners. Political prisoners were typically described as suspected communists, but all it took, many things could get you to be a political prisoner in Vietnam. I'm told I should sit down. I will invoke the example of the Con Son prison, the tiger cages of the Con Son prison. When the American congressional delegation found those, they had been led to them by people who knew about the existence of these tiger cages. The American advisor at Con Son, fully aware of what they were finding, berated them for going off the designated route and tried to seize the camera. The consequences of othering torture, I think, are quite severe. Not only does it give us a false sense of blamelessness, but it also has a corrupting effect on the people who we have do our dirty work. And it also leads to leads or reinforces the notion that these are brutal people, this is a savage war, and all they understand is brutality. I better sit down.
Okay, we have time for just a couple of questions before we break for lunch. Please wait for the mic.
I have a question for Laura Dickinson. It was reported about a year ago that one of the American companies doing outsourced work in Iraq had employed over 120 former apartheid South African police and army officers, many of whom had criminal records including murder and torture. I'm not sure that your age procedure covers that sort of thing, and I was wondering whether there shouldn't be enough.
No, that's very important. It could fall into the accreditation of the companies, because if they were rated, that could be a reason for giving them a very, very low ranking. But that's a very important point, that not only companies with prior cases of abuse, but individuals with prior cases of abuse could be absolutely barred from being employees.
Who would
Yeah.
never qualify for an American visa,
Right.
working for an American.
Yeah.
Well, let me add just one caveat to that, 2 seconds, which is that the Federal Register requirements that were promulgated in May of this year do include a vetting requirement. The problem is, which would deal with those kinds of situations, the problem is there's no hook to that. It's simply a paper requirement that there is vetting, but that process is left to the discretion of the contractor, and there's lots of incentives and lots of ways around that requirement, and there's certainly no oversight, which is what Laura's point was.
question is basically, is it really a gap in the statutory base, or is it a gap in the prosecution? In that respect, I'm speaking to corporate criminal liability. Why haven't we used the same theories of corporate criminal liability in prosecuting this type of activity? And for an example, the healthcare industry, if we had used that same type of principle, these companies would be disbarred and would not be permitted to continue in that particular type of conduct.
Well, there are efforts to use litigation against these companies. I mean, there's the civil suit brought against CACI under the Alien Tort Statute, but there are various legal hurdles there. While it's certainly, in my view, worth pursuing such remedies, I think it's important also to think about these alternative contractual type approaches to enhance accountability. And so, for example, the equivalent from the contractual frame would be blacklisting certain companies.
I have a line that I use all the time when I'm training soldiers in law of armed conflict obligations. I say the wrong time to learn about the law of war is in the context of your court-martial. You'll learn a lot about that. And in fact, there's an awful lot when we talk about personal criminal accountability. That's much different than saying there's a broader corporate accountability. And let me give you one example of the kind of thing I'm talking about gaps. The old Military Extraterritorial Jurisdiction Act applied only to DOD contractors. Now, CACI, that was a Department of Interior contract. So under the old statute, that didn't apply. Well, Congress sort of said, gee, that's a problem. Let's fix it. So they fixed it. In the 2005 Authorization Act, they expanded it to be not just DOD contractors, but any contractor from any government source in a combatant command supporting DOD activities. That's a good thing. You've now got personal criminal liability. You've expanded it. And at the exact same time, in the exact same statute, they changed the definition of special maritime and territorial jurisdiction, which then excluded media. That's what I mean about a consistent tapestry that we're missing in terms of a focused, thought-out hierarchy of statutory enforcement.
Okay, hopefully one last quick question.
This is addressed to Colonel Newton. My name is Jerry Berkeley, private U.S. Marine Corps. I want to know four things. Are you a ring knocker? Do you teach the Nuremberg trial law to the cadets? And was your talk pre-cleared? And are you endangering your career if it was not pre-cleared?
No comment, no comment, no comment.
Okay, thank you very much to our wonderful panelists. We'll break for lunch now. If you'll head out the doors and go to the right to rooms A61 and 62, pick up your free lunch and bring it back here for our lunchtime panel at 12:45. Thanks.
You don't know what the Superman's litigation.